Hello, everybody. Welcome to my live. Well, I have some appointments this morning, so we're doing a live early. Although it depends where you are. It's 6:30 a.m. here, Pacific Coast Time, Pacific Standard Time. All right. So what's going to be the subject for the live today? Well, I get so many calls and so many of the same type of situations regarding this. I want to do a live on it. The bottom line is a lot of people say, I'm going to marry my spouse. Can she come in on a visitor visa and can we get married? Okay, things like that. So I'm going to be talking about non-immigrant intent and what that is. Okay? And then what I'll do is I will go back and I will answer the questions you have. We have not a lot of time this morning, but we have enough to be able to go forward and, answer whatever you can in regards to immigration. So, let's get to it. All right, so what is non-immigrant intent? Okay, why is that so important with a visitor visa? And the bottom line is, just putting it in simple terms here, when you come to the U.S. as a visitor, you must intend to return to your home country. Okay, that's non-immigrant intent. You must not intend. I'll say it the other way. You must not intend to become a resident, become a citizen, stay here forever, overstay. You must intend only to visit temporarily and then go back. Now that doesn't mean, because I know people are going to say, well, I know someone who came on a visitor visa and then later got a student visa, changed the status to student and then work and then the green card and then citizenship. And they were here forever. Okay. Distinguish what I'm saying here, though. You can later change your mind as to what you want to do. But at the moment you enter the U.S., you have to have that non-immigrant intent. Okay? You have to agree that and understand that you're going to intend on going back to your home country. Now, I have a lot of people say, well, I intend that, no problem. But, just saying you do and proving you do are entirely different balls of wax. Okay? There's also another area of law, which is strange here, that a visitor, someone who applies for a B2 visitor visa, is presumed to not want to go back. Okay, that's like being guilty before being proven innocent. Okay, so thanks for the roses and the chili peppers. So you have, I appreciate it. Thank you, businessman. You have to have that non-immigrant intent in order to be approved. You can't have what's called dual intent. I like businessman because he sends me all kinds of stuff. It's so funny what they have. So appreciate it. Dual intent is when you have the intention to come here and then go back to your home country, but you also have the intention to stay here and get the green card. It's sort of strange, right? You're saying, how can you have both intentions at the same time? But there are visas that allow that, okay, such as the H-1B, the O-1, okay, things like that. So if you're coming on the visitor visa, there's all kinds of stuff you can use to show and to prove that you have non-immigrant intent. You can show the job that you have back in your home country, that's still there. You can show assets that you have in your home country, like a house and car and rental statements, and you're not going to leave that. You can have declarations, affidavits. You can show other ties to the home country, insurance policies and so forth, bank accounts, things like that. That will assist. You can also, strangely enough, leave part of your family in your home country, rather than all of you coming here, because there's a higher chance that you're not going to stay here forever if your family is back in your home country. Okay? So this is the biggest issue with B2 visitor visas. There's a lot of other issues, and I've done a lot of videos on the other issues. But the non-immigrant intent is the absolute biggest issue that exists. Okay? So you can understand when a client comes to me and goes, you can understand now, when a client comes to me and says, I've had a fiance for, 4 years, and I want her to come to the U.S. on a visitor visa, and then we're going to get married, and then I'll apply for her green card. Okay. What jumps out at you when someone says that? Well, they don't intend to come to the U.S. to visit. Okay. They intend to come to the U.S. to get here easily, and then do what they really want to do, which is get married and then get the green card. Okay? And so when that happens, when someone comes here and then thinks that they outsmarted the system, and then they get married and they stay here, they now are likely to have a charge of fraud against the foreign national who did that. And what is the fraud? Because I have people who will say, I didn't commit any fraud. I just came on a visitor visa. Well, the fraud is that you didn't have non-immigrant intent. The fraud is that you used the B2 visitor visa as a subterfuge for the real immigration system of having to wait and do consulate processing or do the fiancé visa, whatever it is, in order to get here quickly, so that you can be with your fiancé/spouse and you don't have to go back and wait. Okay? And I have people who, go on the internet and they go, okay, you're not supposed to do a marriage petition for at least 90 days after you enter. That way you can show you didn't have intent. Okay? You can get married 91 days after, and yes, the presumption of fraud no longer is there. But it doesn't make the issue disappear. Okay? I mean, they're still going to question you on your intent. I have people who do that, and then they go to the interview by themselves, and they go, yeah, well, I was pretty sure I wanted to get married when I came in. I just waited 94 days. Boom. Denied. Okay? Because they didn't have the non-immigrant intent. All right? Does all this make sense? Okay. It's the kind of subject that really, sorry, I might have to get up and get a drink. It's the kind of subject that doesn't take a long time to discuss, but is critically important to understand. Okay? So if you ever come on a visitor visa, B2, make sure you not only have a non-immigrant intent, but that you can prove it. Thanks for the hearts, everyone. All right. So let's... Jeez. I'm going to get some water here. Okay, let's go back and see what questions we have. By the way, as an aside, while I'm looking for the questions, I'm like 2 weeks away from 60 years old, right? I know I only look like 40. Come on. But I have just been, I've been practicing law for, God, it's been 33 years. Holy cow. I've been practicing law for 33 years. Okay? I bet you half the people watching me are not even 33 years old. And I was admitted to the uh, to the California bar. Okay, that's where I took the bar. That's where I did everything necessary. And with immigration law, you can practice all over the United States because it's federal law. However, I have a lot of cases. Like it turns out, a lot of cases like in Texas where I have to, we had to go to criminal courts to try to vacate, and it was hard to associate local counsel. And even if we could, they weren't immigration lawyers, so they didn't really know so much what to do, and they don't allow you to appear for state matters, and for other reasons. I had done some research because I honestly I didn't want to take the bar again. That's like a one-time deal. Um, but there's different states that they have ways of applying with all of your years of experience and references and good moral character. I mean, you got to meet a bunch of requirements, but they'll call it, what Texas called it was admission without application, or AWOX. Okay, so I'm happy to report that I have gone through that whole process and now have been formally admitted to the Texas bar as an attorney in Texas. Thank you, thank you. So now I'm licensed in California and Texas, and I have contacted the Texas Supreme Court because you can get sworn in by a Supreme Court justice there, in sort of like a private hearing. And so I'm going to bring my wife and kids, and some other people are going to come. I'm going to fly into Texas, and we're going to do it right around my birthday. Is that funny? If they can get me in. I mean, the clerk is finding to see if a judge can get me in at that time. But won't that be cool? I will go in, get sworn in, and my birthday will be there. So we'll have some fantastic Texas barbecue after or before, depending when the day is. Okay, well, a little bit about me. Okay, let us go down and see what questions we have. Okay, just a minute. I have to scroll down, so everybody be patient, because a lot of people that joined, but not everybody has a question. That's how it is. Business Mindset, you got the #1 gifter badge again, and you also sent me the roses, the chilies, the lightning bolt, and the goat. Thanks. Okay. Oh, and the squirrel. That's so funny. And the heart puff, and the TikTok, and the corn. That's so funny. Okay. What state are you in, sir? Well, I'm in California. But I have, this is for share, but I do have, like I said, I have clients all over the U.S. Because when the bottom line is, you want to get someone who knows what they're doing and who's an expert in immigration law rather than someone who happens to be local. But now I can say I am officially licensed in both California and Texas. Okay. This is from Shifa. How are you? I'm fine, thank you. How are you? Can I file an I-130 while the 730 is pending when I just applied for the I-N-400? That doesn't make sense. That sentence does not make sense. You're asking if you can file the I-130, which is a family-based petition, while the I-730 is pending. The I-730 is, when you are a derivative asylee, okay, meaning that somebody who is, you're a dependent of someone who has been granted asylum. I suspect the first part of the question makes sense. I mean, you might have a sister or brother who's in the U.S. who can petition you. That will take many years. And you might be one of the unfortunate people where, Trump has put his foot down and said, well, it doesn't matter that you won asylum, went through all the, legal procedures to do it, but we're going to stop all the green card processing now for those who won the asylum, which he's done, and there'll be lawsuits, and eventually that'll get overturned. But the answer is yes, you can file an I-130 while the 730 is pending. What doesn't make sense is when you say you just applied for the N400. That doesn't make sense. I mean, that's saying you're going to apply to become a U.S. citizen, which means you already have the, the green card. Unless you're the one that is the one that wants to apply for someone coming in under I-130, okay? So call me so I can get straight who is who to verify the facts of your question, okay? Alrighty, let's see. Donnell, you just got the #1 gifter badge, which was quickly taken over by Todd Lacey. What if you have a baby on a B2? Will it be an issue for re-entry? Well, it's possible, okay? I mean, when you come on a B2, you're going to have 6 months, which means if you had a baby on the B2, you had to be, and you didn't go out of status, you had to be at least 3 months pregnant when you walked in the country, okay? Which is okay, but you have the baby, and the baby's a U.S. citizen, and now you want to come back. So the issue is, when you come back, assumably on a B2 with a U.S. citizen baby, are you still intending on going back to your home country? And that becomes more difficult to prove, okay? Because they're going to think you're going to want to, get medical care for the baby here. You're going to want to start getting things here, for babies that are born in the U.S. because the baby's a U.S. citizen, and your intent will be significantly put in question. Okay, so yes, it does affect you. It doesn't mean you can't do it, but it does affect you. Okay, for Tony. I'm in a final order of removal, but out on habeas corpus. If I don't check, what'll happen in the next 4 years? Well, that's interesting, because normally, if you have a final order of removal, then you can just be removed to your home country. So the only thing I can assume is that you have a final order for removal and your country won't take you back, and they've had you in detention for a long time, and they won't because they can't deport you. I can see a habeas corpus being granted in that particular respect, and that, they can't keep you detained forever because your home country won't accept you, and they could make you go back to immigration every 6 months or whatever until they do, and to make sure you're still complying with the rules. I don't know where you're getting I know where you're getting the 4 years. You're trying to outlast Trump. There's a lot of questions I'd have to ask as to the specifics of your case, but if you're out on habeas corpus, there must have been a reason, a significant reason, especially with an order of removal. So you'll need to comply with, the rules to go see immigration. I would see an immigration attorney, such as myself, to see if you qualify for anything else, and or if we can maybe do a motion to reopen to get the removal order reversed. Maybe it was in an absentia order, maybe it wasn't properly entered, maybe you qualify for something else right now. Okay. All right, let's see. We have time for a couple more. Oh, Andrea says congratulations. Thank you. And so does Alma Hernandez. Appreciate it. How much would it cost approximately to immigrate from Thailand to the U.S. with a fiancé visa? Well, Todd, it depends. Okay. I mean, if it's a straight fiancé case with no issues, which, to be honest with you, these days every case, except very few, have issues. You do the fiancé visa, and typically that's between $1,500 and $2,000 attorney's fees plus the filing fees, and then assuming everything goes well, they come here, then you do the adjustment, and the adjustment is usually around $2,500 attorney's fees plus the filing fees. Okay. All right. Have you noticed IJs and DHS lawyers become more strict in merits hearings under the new admin? Yes, This is for Sal. Yes, absolutely. I haven't just noticed that they've become more strict, but some have become outright rude and unnecessarily adversarial. Okay. Which, as a lawyer, I find that a bit embarrassing because to be a good lawyer, you don't have to be like, a wrestler slamming it down their face, yelling, screaming, denying everything. Okay. You can make legal arguments against something and make it professionally and make it coherently, and you can make your point known. I even had a particular DHS lawyer who used to work for me, okay? And she was actually pretty good. And then she went to the other side. And so now she's, a trial attorney with DHS. And she's been reasonable, arguing and everything. But after the Trump administration, they must have had orders to, deny and fight everything. That's the orders that came down. And I understand that they're in a position that they have to follow those kind of orders, but they don't have to be rude and obnoxious and so unbelievably adversarial. Okay? It doesn't intimidate a good lawyer by being like that. They may think it does. They may think also it intimidates the respondent, the person in proceedings, which it probably does. But, you know, people like me, we just keep our cool. We let them go on their spouts. And then we argue the law and we argue reasonably like it should be done. Okay? So the answer to your question is yes. Okay? Let's see. DFMO 981. That's a hard name to remember, but you just got the number 1 gifter badge. Okay. Well, there's been different EOIR memos. There was actually one that was just put out where they're going to decrease the number. This is actually with the BIA, but they're going to decrease the number of BIA judges by like 23%. It's craziness. Craziness, I tell you. Okay, how long does it take for an I-765 to be approved after doing your biometrics marriage-based case? Those take a few months. It's no big deal. Not a long time. Sarah got the number 3 gifter badge. All right, we're getting to the end of our time together today because I have to head to some appointments. Good morning, attorney. Good morning, Sarah. Is it safe to travel on a green card now that I had a dismissed misdemeanor? That depends. Why was it dismissed? Was it dismissed because you complied with the orders of the court and it was a deferred adjudication? Was it dismissed because you were on probation for 2 or 3 years and then you completed it? So I need to see why it was dismissed, because in immigration law, even if something's dismissed, it might still be a conviction. Okay. This is from Lots. Hi, if an international student out of status for almost a year, is it possible to be reinstated? Yes, it's possible. I need to know why you went out of status. What happened? Have you worked while being out of status? Sarah, how safe is it to travel out of the country? Not very these days. It's lunacy what's happening. Okay, I mean, there's lawsuits going up and down. That person from El Salvador that they improperly deported, and they admit, oops, sorry, made a mistake. And the U.S. courts have ordered them to bring him back. The president of El Salvador and the president of the U.S. have raised their hands. So we know it was wrong. Sorry, but we can't get him back. There's nothing we can do. I mean, is that a load of baloney or what? Everybody knows it's a load. Everybody knows if they wanted to follow the orders of the court, that person would be back in the country tomorrow. Okay, that's what we're dealing with these days. Okay. But yes, it's possible to be reinstated. You just have to do a good F1 reinstatement petition. Okay. How can I get a consultation? Sarah, you can call my office, 562-495-0554. You can email me. There's all kinds of ways. And of course, I'm on social media up and down. All right. So that is going to do it for today. I hope everybody has a good day. 7 o'clock in the morning. So you're probably all just getting up having breakfast. All right. I'll sign off for now. Have a good day.